of the afternoon. Senator John Cavanaugh in LB321. Welcome, Senator.
Thank you, Chairman Lathrop, and thank you, members of the Judiciary Committee. My name is John Cavanaugh, John Cavanaughh. I represent Legislative District 9 in Midtown Omaha. I'm here today to introduce LB321, which would prohibit the so-called LGBTQ panic defense in Nebraska. The defense aims to demonstrate that the defendant's conduct resulted from the discovery of the victim's perceived gender identity or sexual orientation, often to show...
Remember when I was reading all this stuff? I'm just going to interrupt you for a second. My committee oftentimes doesn't even show up to hear it anymore. They've heard it so many times, and apparently it still hasn't sunk in.
That's the first time in 7 years, though.
That was even an alarm, it sounded like. Anyway, Senator Cavanaugh, I apologize.
That's okay. Thank you, Chairman Lathrop. This defense aims to demonstrate the defendant's conduct resulted from the discovery of the victim's perceived gender identity or sexual orientation, often to show that the defendant lacked requisite mens rea to be guilty of the charged offense. It usually takes the form of an insanity or diminished capacity defense, a provocation defense, or even a claim of self-defense. 11 states and the District of Columbia have banned this defense, and legislation is under consideration in many other states, including Iowa, which passed the bill, similar bill, through their House unanimously last session, and I think is taking it up again this year. This defense plays on the damaging and untrue stereotype about LGBTQ people, seeming to suggest that they deserve violence committed against them because of who they are. In 2013, the American Bar Association passed a resolution urging legislative action to curtail the availability and effectiveness of the gay panic and trans panic defenses. This bill was introduced 2 years ago by Senator Hunt as LB 166, and during the hearing on that bill, opponents raised some points which I will try to address here. The Supreme Court in 1993 case State v. Lowe did not allow evidence to be introduced of a victim's sexual orientation because it was not relevant. The defendant in that case advanced a gay panic defense, but crucially, the court was silent on whether such a defense was allowed at all. In fact, the court's opinion stated evidence of a murder victim's homosexuality may be admissible as corroborative of a defendant's claim of self-defense from a homosexual act, provided such defense as tendered is probative of that defense, before concluding that the evidence in the case was not probative. But in State v. Escamilla in 1994, the Nebraska Supreme Court held that there were a defendant there where a defendant claimed the act of killing a victim was the result of a violent and overriding reaction to a homosexual approach by the victim. Evidence of that victim's prior similar homosexual activities may be admissible under certain circumstances as corroborative of the defendant's claim that there was a lack of deliberation or premeditated malice on his or her part necessary to convict of first-degree murder. There was also no argument that the legislation could conflict. There's also no argument that the legislation could conflict with the hate crime statute or prevent defendants from presenting evidence in their defense on an essential element of the hate crime. I do not view these as conflict, as the ABA's resolution in 2013 stated these defenses are irreconcilable with laws that treat crimes motivated by sexual orientation or gender identity as aggravated offenses. But I'm also a defense attorney, and I understand that other concerns raised here regarding the ability to present evidence, and I'm willing, of course, to work on those concerns in good faith if we can. One more thing I will note as it relates to hate crimes law in Nebraska. Sexual orientation is a protected class under our hate crimes law, but gender identity is not. My understanding is Senator Hunt had a bill to change that, but she intends to withdraw that bill, and I understand her reasons for doing so. But under Nebraska law, a defendant asserting a trans panic defense may not be admitting to a hate crime. This committee has heard many bills on the subject over the years, and you will hear a few more here today. And while I've tried to address the good faith criticisms I expect to hear, I do want to take time to address something else. Every person has a right to be treated with dignity. Too often on bills such as those you'll hear today, many opponents will seek to rob LGBTQ people of their dignity, and those who have come before you stand up for their rights and their dignity must sit and listen to the insults and assaults of their character. I want to acknowledge them and the LGBTQ Nebraskans watching this afternoon. You have worth, you have dignity, you're valued, and your laws should reflect that. Thank you for your time, committee, and I'd ask you to advance LB 321, and I'm happy to take any questions.
I do want to ask one question, though. So, in the context of the difference between first-degree murder and second-degree murder, first-degree murder being premeditated, second-degree being sort of in the spur of the moment, oftentimes most frequently characterized by, I came home from work early and found my wife in bed with somebody else and I shoot them both. That would be second-degree murder because it happened without premeditation, but there's something that triggered it, right? Would this prevent a defendant from offering evidence that something like this took place and it wasn't premeditated, but rather on the spur of the moment?
So,
you following me?
I do. My answer would be that this bill would only prevent you from asserting that that precipitating event is the perception or discovery of the perceived gender identity or sexual orientation. So in the scenario you're establishing, it would, as long as that precipitation would be not related to that, then that would still be a distinction. But it's
what if that's the thing that sets me off? And I'm trying to prove that it wasn't premeditated, but that something set me off, and this is it. It set me off.
Well, so you're saying that you hope.
What if it's not a defense, right?
You would not be able to.
You don't get to kill somebody because of this.
Right.
On the other hand, it may explain why what you're being charged with wasn't premeditated.
Right. So you couldn't, under this law, you wouldn't be able to use that as a mitigation for the prior intent. In the scenario you're establishing, that the lack of premeditation itself would not be established in that circumstance. I guess I'm failing to see that situation there.
If the prosecutor has charged me with first-degree murder and said I came over on purpose, premeditated, had an encounter with somebody, and premeditated, and I killed them. If I'm the defendant, should I not be able to offer whatever explanation is inconsistent with premeditation?
Okay, I see what you're saying. So essentially that is what this bill is attempting to address. It's saying that you could offer any reasonable explanation that would explain your lack of premeditation. It is saying that you can. This is not an acceptable mitigation to premeditation, and that you couldn't.
Shouldn't it be though?
Like,
I mean, why should we shut the door on anybody be able to prove? By the way, I'm not okay with this, all right? But I am trying to make a distinction because being charged with first-degree murder, premeditated murder, is the most serious thing we can charge somebody with, right? And if I act on an impulse, for whatever reason, it's no longer premeditated. That's a defense, right? Not to the murder itself, but to what degree I'm going to be convicted. And would this close the door on my ability to say, this wasn't premeditated, jury. I freaked out when this happened, and I did it on an impulse.
Right, and so the distinction here is that this happened that caused you to freak out is the gender identity or sexual orientation of the victim. And so what it's saying is that I think you're establishing a scenario in which you're trying to explain the reasonableness of a assailant's assault on somebody because of their feelings about that other person's gender identity or even their perception of that person's gender identity. And that's exactly what this is seeking to address, is to say that is not an acceptable mitigation. You're asking what is an acceptable mitigation and whether someone should be able to assert any mitigation. And what this bill would say is you should be able to assert any mitigation within reason, right? And this is one that we have established, other states have established, is not an acceptable mitigation for your subjective perception about the victim. And so it's saying that is not a mitigation for your behavior. It's not saying that automatically if you kill somebody that you're not entitled to other mitigation. You just can't use your discovery of their gender identity or sexual orientation, or even your perception of it, as a mitigation to diminish your intent.
Well, I guess we can see what everybody has to say. I just want to throw that out there so that you have an opportunity to think about that as people testify, and maybe we have a further conversation, if it's appropriate or necessary, in your books. Anyone else have a question? I see none. Thank you, Senator.
Thank you.
We will take proponent testimony at this time. If you're in favor of the bill, you may come forward and be heard.
Adam Downes, ADAMDOWNS. I'm not a lawyer, right? So in my research for this, I found the American Bar Association endorsement, and what I wanted to actually do is just read a portion of that into here, but I will note that I did change the name and the pronouns of this because this is telling a story of somebody in there, and that person had requested a female name about a week before she was murdered. So Letitia King, 15, was open about being gay. She was teased and bullied incessantly from the age of 10, but she was proud of her identity and openly expressed it through makeup, accessories, and high heels. She had the support of some of her school's administration, who stood up for her when students and teachers expressed concern about her appearance. Despite this support, one day after saying "love you, baby" to a male student, Letitia was shot to death in a classroom in front of her classmates. Letitia did not touch Brandon McInerney. She never threatened Brandon. She did not make any advances toward him, and she did not put him in any kind of danger. The day before she was murdered, Letitia, wearing makeup and high heels, simply asked Brandon to be her Valentine. Brandon's defense at trial was that Letitia was sexually harassing Brandon and that Letitia's words and wardrobe were responsible for her death. His attorney argued that Brandon was just responding to Letitia, whom he described as an aggressor and a bully who was known to make inappropriate marks and sexual advances to males. Brandon's attorney did not claim that Letitia assaulted Brandon or threatened his safety. He didn't have to. Following this strategy of shaming and demonizing the victim for her sexual orientation, the jury hung when trying to decide if Brandon was deliberate and wholly blameworthy in killing Letitia. Sadly, Letitia's story of murder and subsequent vilification is not unique. And that's where I'll end the quote from the American Bar Association's referendum on this. And what I'd like to do is maybe throw out a couple of other instances where this has occurred so these names are not forgotten, because they deserve acknowledgement that the system has failed them, and that they didn't receive the bare minimum of human decency and respect. Chanel Pickett, murdered. The murderer was convicted of assault and battery and got 2 years in jail. Jamaica Green was stabbed 21 times. Her murderer, not guilty. Scott Amador, the jury reduced the charge from premeditated murder to second-degree murder. Ahmed Dabaran, despite the confession, a confession from the murderer was acquitted. Guy Richie Phillips, strangled, stuffed in a suitcase, dumped in a lake. Jury convicted of the first degree, or the second degree murder rather than the first degree, and the murderer became eligible for parole 2.5 years after his conviction. All of these instances had the LGBTQ panic defense utilized. It was used as a strategy to get the jury on their side, to try to create empathy for the murderer who failed to recognize just an identity of a person, right? And with that, I'll close my statement. Thank you.
Okay. Thank you, Mr. Downes. I do not see any questions for you.
Thank you.
Other proponents of the LB321? Seeing none, we'll take opposition testimony. Anybody here to testify in opposition?
Good afternoon, members of the committee. My name is Spike Eicholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the Nebraska Criminal Defense Attorneys Association in opposition to the bill. We are opposed to the bill in its current form, and we are opposed to the ultimate purpose, or at least the intent of the bill itself. With respect to the current form, if you look at the bill, it does far more than simply allow for a mitigation argument to be made, differentiating between first and second degree murder on this purported gay panic defense. If you look on page 2, lines 1 through 6, the court or jury shall not even consider evidence, nor shall it be defense to an offense or negate an element of a criminal offense that the defendant's conduct resulted from the discovery of, knowledge about, or potential disclosure of the victim's actual or perceived gender or sexual orientation. If you look on lines 23 and 24, the definition of gender means sex and includes a person's gender identity and gender expression. Everyone presumably has a gender. It's not just a defense of temporary insanity. It's an absolute bar to the admissibility of evidence. We already have in statute current limiting statutes that allow for evidence to be admitted for limited purposes. 27.412 is the rape shield law. In most circumstances, an alleged victim of sexual assault, that person's sexual past cannot be adduced as evidence. There are some exceptions to it. There's a process. The defendant gives notice. The judge has a hearing. The judge determines whether or not it's admissible, and if so, for what purpose. This bill doesn't cover any of that. Similarly, we have the 27.404 admissibility. We have the opportunity a defendant can to raise an insanity defense. Under 29.2203, we have to give written notice to the court 60 days before a trial, at least 60 days to the state, with any sort of expert opinion accompanied with it. The state has the opportunity to get their own expert to consult and evaluate the defendant if you raise that. This doesn't talk about that. It's an absolute bar of admissibility of evidence. You can't raise it. You cannot argue it. With respect to State versus Lowe, I made that point earlier because in that case, Lowe tried to raise a gay panic defense. It was rejected by the trial court, and the Supreme Court affirmed that. There hasn't been any successful argument in Nebraska since then on this type of defense. No one can say who was found not guilty in Nebraska, who walked free. It does not necessarily conflict with the hate crime statute, but if you are going to argue as a defense that you intentionally did the act because of the sexual orientation or the gender of the person that you did the act to, you are not only acknowledging that you committed the crime, but you're acknowledging to the aggravator of the hate crime. So that's the point. It's not necessarily a conflict. With respect to the form of the bill, and I don't mean to say this crudely, but I want to be clear, I don't think it's wise policy, legislative policy, for the legislature to put in statute a limitation on a defense or a mitigation argument because it may be offensive to people that may be raised. You ultimately have an opportunity and a right to defend yourself when the state's coming at you on a serious charge. And I think that sets a dangerous precedent to start with this. I'll answer any questions if anyone has any.
Any questions? I don't see any, but thanks for being here. Anyone else here to testify in opposition to LB321? Anyone here to testify in a neutral capacity? Seeing none, Senator Cavanaugh, you may close. We do have some written testimony and 12 position letters. All of the letters are. We also have written testimony provided this morning on this bill. As a proponent, Abby Swatsworth from out in Nebraska is a proponent. Opponent is Marion Miner with the Nebraska Catholic Conference. And also opposed is Nate Graz with Nebraska Family Alliance. Senator Cavanaugh.
Thank you, Chairman Lathrop, and thank you to the Judiciary Committee, and thank you to everyone who is here today testifying on both sides. Mr. Eicholt and I have spoken about this bill a number of times, about our divergent opinions, and I have tremendous respect for him, and I would just say he always speaks very artfully, so when he said he didn't want to be crude about it, I just think he deserves credit for how well he presents before this committee, and I just want to recognize that before I disagree with him. Mr. Eichelt's proposal here is that there are ways that we have constrained other places in the law, which is fine to create a mechanism for an outlet. That is to allow for necessary and I think considered relevant evidence. What we're saying here is that this is not just an offensive proposition to claim mitigation because of the sexual orientation, gender identity of the individual, the victim, but it is not an acceptable defense. And going back to kind of your analogy, Chairman, in that scenario, if it were a man who comes home to find his wife in bed with another man, that would be second-degree murder. If a man comes home and finds his wife in bed with another woman and murders them, that would be second-degree murder as well, regardless of the circumstances. If you come home and you only murder the other person because of the specific gender of the individual with your wife, that would not be an acceptable mitigation. And I think that's the distinction here, is that the situation is the same, should be the same regardless of the gender of the victim there, and that you should not be able to claim a mitigation because of that. And I think that's kind of the confusion. I just wanted to additionally point out, I don't know if I read it specifically out of Escamilla, but as Mr. Eichel said, nobody has asserted this before, and Lowe specifically didn't deny it, but I would just tell you, the wording in Escamilla is clear. We hold where defendant claims that the act of killing the victim was the result of a violent and overriding reaction to the homosexual approach by the victim, evidence of the victim's prior similar homosexual activities may be admissible under certain circumstances as corroborative of the defendant's claim that there was a lack of deliberation and premeditated malice on his or her part necessary to convict of first-degree murder. That is the state of law in Nebraska. That case is cited to in 27404 in the notes attached to 27404. So it is clearly established. And what Escamilla is a case about is an ineffective assistance of counsel case. This is a case where they didn't raise this, and he appealed and lost on other grounds. But reading of this would be that a defense attorney could be construed as ineffective if they fail to assert this under that state of law. And so, if there are any other questions, I'd be happy to take them, but I appreciate your time.
I would just make this observation that as I read the first paragraph or first section, this would stop me. Let's say that someone is about to out me, okay, out my gender identity. They've just found out, and now they're like, I'm gonna go tell people that this is true about you, Lathrop, and I shoot him. I'm gonna wanna talk about it in my defense because someone just basically threatened to out me. So this thing swings both ways. It's not just I found out about it and then I punched somebody, or I found out and then I shot somebody. It's also the disclosure, right? Well, that would be the disclosure of the victim.
Well, this pertains to the gender identity and sexual orientation of the victim and not the attacker.
Senator DeBoer.
So, if I'm making this is probably too elementary, but if I'm making the distinction between first degree and second degree murder, if I'm the prosecutor, I have to prove the premeditation, right?
Yes.
Okay. So if my defense is I wasn't premeditated because I found out some information that surprised me as I guess what it would be if you discovered someone's gender identity was different than you expected. You still, the burden of proof is still on the prosecutor to prove that even if I can't use the defense that was my surprise, the burden of proof is still on the prosecutor to prove that you premeditated, right?
Correct. And essentially, yeah, what this bill is saying is that the defendant couldn't raise that surprise as a mitigation to that.
But this is where I need help. What does that, what do you mean by the mitigation of it? I mean, I know what the word mitigation means, but.
So to claim that it was not premeditated and to claim that it was in the heat of the moment.
But there isn't a presumption of premeditation, is there?
No, they'd have to establish by the evidence that the circumstances prove the elements of the crime. Right.
So what I'm saying is I don't think this gets to the first and second degree thing that the chairman was worried about. If I am in a situation, I discover someone's gender identity or expression is different than what I thought, I react in that moment in some heinous way. Later, if I'm asked, or if the prosecutor's trying to prove whether it's first or second degree murder, does it matter whether or not I could raise this defense in order to determine whether or not it's first or second degree murder? Because the prosecutor still has to prove it, right?
Well, the prosecutor still has to prove whatever crime. This is not just first or second degree murder. This is in mitigation for any offense that would essentially you would potentially raise. So I guess I'm not quite following the question.
I guess I'm saying, does this bill change anything about how, as a prosecutor, I would try to, let's say we pass this bill, the prosecutor doesn't have any change in what they have to do. So it would be the defense attorney, maybe the defense attorney can't raise that that's the reason, but the prosecutor still has to prove that there was premeditation. And if in fact it was a surprise that happened quickly, then there wouldn't be any evidence of premeditation.
Well, I suppose it depends. What a jury is going to find as evidence of premeditation and what a prosecutor, how they're going to present it. Particularly in the Escamilla case, was Mr. Escamilla murdered someone by stabbing them a number of times, sort of in the middle of a sexual act, and then he wanted to claim that had he known that person had a previous past of, I think that in that case there was pedophilia, that he would not have pled in that case. And so that he thought that he shouldn't have been charged with first degree murder because if he was able to present that evidence, then it would have mitigated it. But in the case, there was other surrounding evidence that sort of
that he was premeditated.
That supported the premeditation.
Got it. Okay, thanks.
I feel like I'm
all this
Supreme
can
Court.
be taken up in a motion and limited, right?
Well,
a pretrial motion where the court says, is this relevant to this particular case? Let me make a judgment under our rules of evidence and under constitutional principles. The court can decide whether it comes in or not right now.
Currently, yes, the court would rule on it. And again, I feel like I'm in front of the Supreme Court or something now. In these cases, Mr. Eichhold and I have had this conversation about that to present the insanity defense, you would have to present additional evidence on top of that. But again, that is the state of the law. So a judge would go back and read Nebraska Supreme Court case law and say they have explicitly said this is acceptable, relevant evidence if you establish it in connection to
assuming it has some relevance.
Right. And in the case law in Lowe in particular and Escamilla, the two cases on point in Nebraska where this has been discussed, they were both pretty poor examples of evidence. They had no real relationship. They were grasping really to make any kind of connection, and that's what the court said. And that's what the ruling was, that these would be acceptable if you brought different evidence that was on this topic. And so I think that's an important distinction here, because I think there have been conversations where people said, what's the point of this? Because it doesn't happen here. But it is the state of the law of Nebraska.
Well, yeah, we don't really buy that. It hasn't happened here yet. It could.
Yes.
Okay. Any other questions? I see none. Thanks, Senator Cavanaugh. We appreciate the
Thank you.
introduction of this bill. We will now move